Morning, Your Honors. Michael Petherick of the Chattanooga Bar here on behalf of the defendant and appellant in this matter, Trader Joe's. At this time, I would ask the court to allow me to reserve 5 minutes of my time for rebuttal. Thank you. This appeal presents this court with the opportunity to address two unresolved questions of Tennessee law. One of the questions will impact primarily premises owners, such as my client, Trader Joe's. The other question, however, will impact all businesses with employees who conduct operations throughout this state. It's a very important question. One of the issues before the court is to decide whether Tennessee should embrace the decisions of all three of its federal courts and of numerous other jurisdictions and adopt what is commonly referred to as the preemption rule or the stipulation rule. And under that rule, if an employer admits vicarious liability for the conduct of their employees, direct negligence claims such as claims for negligent training and supervision are deemed to be no longer legally sufficient. Once vicarious liability has been admitted, direct negligence claims have no purpose. The employer will be completely not liable for all negligent conduct perpetrated by its own employees. The preemption rule promotes judicial economy, it streamlines discovery and litigation, it prevents prejudice to defendants, and we contend it is consistent with Tennessee law. This court should adopt the preemption rule and reverse the trial court's order denying my client's motion for judgment on the pleadings.
Counsel, let me ask you a question about what you just said. What did you just say about defendants, how it protects defendants? Is that what you said?
Well, so there are some evidentiary concerns. Obviously, with your standard vicarious liability case, once vicarious liability is established, all the plaintiff has to prove is negligence of the employee or the agent or whoever else it is, along with damages.
I understand how it works, but you articulated a policy reason, and I wanted to make sure that I understood that. Did you not say that there was a policy reason in favor of the rule about defendants? And can you clarify what you meant by that?
Yes, Your Honor, and I'll speak to that. That has to do with a lot of evidentiary concerns and what comes out in discovery with these direct negligence claims. If it's just a simple standard slip and fall case or a simple car wreck, discovery is generally more limited in scope if there are no direct negligence claims. When there are direct negligence claims, all sorts of stuff is opened up. Potentially inflammatory information can come out in front of the jury.
But that policy consideration then would only have effect if it was a single defendant case, correct? Employer, employee? If we count those as one defendant?
I'm trying to make sure I understand you. When you say single employee, are you still meaning that you have both the employer and the employee as defendants in one case?
Yes.
Okay, correct. Yes.
Okay. Well, let me give you a hypothetical here and tell me which way this cuts as we consider comparative fault, the comparative fault system that we have in Tennessee. Let's say that there's another defendant. So there's a speeding buggy driver, comes around the corner, plaintiff jumps out of the way, hits the wet spot, falls, has an injury. So the defendants then are the speeding buggy driver, the employee who didn't clean up the spot, and the owner of the premises or the retailer or whatever we want to call it, the employer of the employee who didn't clean up the spot. So the speeding buggy driver then alleges comparative fault against the employer and the employee. Employer argues that the preemption rule applies. So in that scenario, that co-defendant, whether it's one co-defendant or 10 co-defendants, would not get, under the rule that you are urging us to adopt today, would not get the employer on the verdict form, correct? And would not be entitled to discovery against the employer.
Yes, and that's a very good question, Justice Starwater, and it actually, your scenario almost exactly mirrors a California case, Diaz versus Carcamo. That was in 2011. The California Supreme Court actually reaffirmed adopting the preemption rule. There was kind of an interesting apportionment of fault in that case. I believe it was 35% to the employer, 20% to the employee, and then also, I think, I'm trying to remember the remaining apportionment of fault, but it was to the non-employed co-defendant. And the California Supreme Court discussed that at length and how the preemption rule prevents odd verdicts like that from happening. Because on the one hand, there was an assignment of fault against the employer of, I can't remember if it was 35%, it may have been, plus, but at the same time, they were responsible for 55% of the plaintiff's damages. So under that circumstance, we contend that it prevents prejudice against the employer and prevents inconsistent verdicts like that as well. It is true, if someone is removed from apportionment of fault, fault has to go somewhere else, but it doesn't necessarily mean, as the plaintiff in this case has argued, that it's going to be apportioned to the plaintiff.
But as a practical matter, though, counsel, doesn't it, if you get the employer out of the picture, it can clearly impact the allocation of fault, can it not? Because let's assume for a second you have an employee who's a very sympathetic witness. And he has done something, he stacked the goods incorrectly and fall on people. And it comes out that this person was given no training whatsoever on, and the records of the employer would show no training whatsoever. Under that circumstance, isn't it relevant for the juror, the trier of fact, to know that? And isn't it going to impact the allocation of fault in that situation if you have a very sympathetic plaintiff, a very sympathetic employee, and just the two parties, the plaintiff and the sympathetic employee? Whereas if you've got the employer there and it's clearly shown that there was very inadequate training involved, it may well impact the allocation of fault.
Well, that's very true, Justice Bivens, and one of our arguments that we assert is, and I touched on this a minute ago, but evidence like that can be particularly prejudicial to defense.
How is that prejudicial? I'm struggling with
when
that.
I say prejudicial, I mean bad for the defense's
I mean,
case.
bad for the defense.
Yeah.
Well, that's actually.
Welcome to litigation.
Yeah.
We all have
I am.
facts we don't want people to
That's right.
uncover.
That's right. How is that just not allowing the plaintiff to portray the context of how this injury happened?
Well, I think my response to that argument would be that if vicarious liability is already admitted, why would they even need to pursue that separate claim?
All right, well, that brings me to a question about a statute then. And I'm looking at TCA 2939-104 G1B. And I'll read it to you.
Thank you.
Punitive damages may be awarded against a defendant based on vicarious liability for the acts or omissions of an agent or employee only if there's clear and convincing evidence, and then you skip down, that the defendant was reckless in hiring, retaining, supervising, or training the agent. So even under our statutes, even in a case of vicarious liability, the statute provides that there can be punitive damages if recklessness in hiring, retraining takes place. So how is what you're arguing for consonant with that statute?
Well, Your Honor, there are a couple of things on that point. First of all, there are multiple versions of the preemption rule. I think we've addressed that in our brief. There are a minority of jurisdictions. I believe North Carolina has this exception. Georgia used to have the exception until they released their new case in 2020. But they recognized an exception to the preemption rule in cases where punitive damages are actually sought. That is not the case before the court today. The plaintiff has not asserted a claim for punitive damages.
But how is just the bones of the preemption rule consistent with this statute? Because the whole purpose of the preemption rule, as you are arguing it, is to exclude evidence of reckless training or reckless hiring or retaining or supervising.
Okay. And I will qualify this. Once again, it's not the case before us, but the punitive damages statute is the punitive damages statute. The Colorado Supreme Court, I believe in 2017, they issued a case in which they addressed this, this issue of whether the punitive damages exception version of the preemption rule should be adopted, and they rejected it. And they concluded that there is no standalone claim for punitive damages. It's just a remedy. But the thing is that people, let's say it's a case where direct negligence claims are the only claims being pursued. That's still entirely consistent with the punitive damages statute.
Mr. Counsel, one thing that is troubling me about your argument is you bring up this reptile theory.
Yes,
bringing in all these snakes and alligators and whatever else you can bring in. And it's all about, you say the plaintiff is muddying the water and prejudicing the jury, but as a former trial judge, doesn't the trial court have the duty to just police all that and keep it out? Rule 403 comes to mind.
Yes, and the trial court does have that discretion through evidentiary rules. But then we have the concerns of whether the plaintiff should be litigating these claims when vicarious liability is already admitted. They've already got the employer on the hook. So courts in other jurisdictions have looked to the potential prejudice. It's not just prejudice. As we discussed, we all have cases with bad facts, but also prejudice to the parties, overly complicated litigation, and the expense of litigating multiple superfluous claims.
Well, but you want to talk about other states, though, and you mentioned the Georgia situation. Georgia specifically abrogated the preemption rule that they'd had in place for years because of comparative fault. Mm-hmm. So why is that not persuasive to us here to not adopt it from the outset? Because even though they have a comparative fault statute, it's in essence the same situation.
Well, and Your Honor, you already touched on this a little, but I would argue that, and you kind of already hinted at this, that the Georgia case is distinguishable from what we have here. We obviously adopted comparative fault through common law. They have an apportionment statute. So my reading of the case from 2020 in Georgia is that they decided that the preemption rule was no longer compatible, or it was incompatible with their statutory system of comparative fault. So respectfully, that's how I would argue that it's distinguishable from.
Well,
but are there any?
I'm sorry.
No, go ahead.
I was going to say, but how is their statute really any different than our common law as far as comparative fault goes?
Well, it's a little different because the statute has specific wording saying that the fault of all potential fault parties, which I don't have the statute in front of me, so I apologize if I'm summarizing it incorrectly, but that they all have to be compared by the trier of fact. We do have a general stating in our common law.
You're saying that's not the law in Tennessee?
Well, there are exceptions to the rule that the comparative fault of all defendants must be compared by the trier of fact at trial. And we went into that in our brief, specifically in Ollie v. Fisher, which this court issued. They recognized that there are exceptions to the common law comparative fault rule, that the comparative fault of all potential tortfeasors must be compared by the trier of fact at trial. And that was actually a factor that was particularly relevant to Magistrate Judge Lee's decision in the Eastern District of Tennessee. That was issued back in 2016, and there have been 10 other federal cases issued since that time adopting the preemption rule.
Someone else have a question? Go ahead.
Let me just ask a quick one. Thank you, Justice Campbell. So it occurs to me, plaintiff's lawyers are clever and defendant lawyers are also very clever. Okay? So the plaintiff sues the employer, but not the employee.
Mm-hmm.
Okay? The employer adds the employee and then admits vicarious liability. What happens in that scenario?
Well, in that, I'm not exactly sure how vicarious liability would even come up. I mean, are they suing the employer just for direct negligence or also for respondeat superior?
Well, either one, but let's look at it this way. Let's say the employer had a policy that it trained its employees to first things first, stock the shelves so we can move product.
Yeah.
And if you see some water on the floor, make sure the shelves are stocked before you clean up the water. Okay, so the store gets sued. And the store says, you know, it was really our employee that should have cleaned up the mess, and she should be a defendant, he or she should be a defendant in the case. And so we'll make her a defendant, and then we'll admit vicarious liability, and we're only liable to the extent that our employee's liable. Can you see a scenario that would ever happen?
I mean, I can say I've never seen that scenario happen. I think it would be against the interest of the employer to try to push fault on their employee like that and add them as a party.
But yet they would avoid all the discovery, and they would avoid all the prejudicial evidence that might be discovered in the whole process if all the blame was shifted to the employee and not the employer, correct? Under the preemption rule, isn't that correct?
Well, I mean, once again, I don't think that from a practical standpoint that an employer would make pushing fault onto the employee is not in the interest of the employer. It is in the interest of the employer in that scenario to avoid discovery, obviously, if there was something to hide. But I don't think it would be in the interest of the employer to specifically point the finger at the employee.
Well, when the employer admits vicarious liability, then what are they doing? Whose finger are they pointing at then?
They're pointing at themselves. They're saying, we've admitted that we will be vicariously liable for the conduct of this employee to the extent that it's negligent.
Is there a middle ground? Or are we faced with the question of deciding yes to preemption, no to preemption? Or is there a middle ground?
Well, I mean, we have raised another issue in this appeal. Respectfully, we contend that the preemption rule should be adopted and that this court should come down one way or another. Obviously, you all saw in our application there's been a lot of inconsistent law that's been issued by various Tennessee courts, and essentially there's a body of federal common law that goes back nearly a decade. But as a second issue, Your Honor, we've also argued that direct negligent claims can't be asserted in standard slip and fall premises liability cases. Premises owners have a non-delegable duty under Tennessee law to maintain their premises and to warn of or remove conditions of which they are aware. It's a non-delegable duty, as I said, and it's a duty that cannot be altered through training or supervision or hiring or anything like that.
So we
Mr.
should have, I'm sorry. You jump
Thank
in.
you. Mr. Patrick, sorry, before you get too far down that road, I do want to go back for just a minute to the preemption rule. And I'd like for you to discuss the interplay, to the extent there is any, between the preemption rule and contribution. There's some discussion of that in the briefs, with, I think, both parties kind of throwing that out as a potential reason to either adopt the preemption rule or not to adopt the preemption rule. I mean, I'll just note that under the Uniform Contribution Among Tortfeasors Act, I mean, that does allow for the filing of a cross-claim for contribution in the underlying tort action. So
Yes.
how does that, I mean, so I assume that maybe in the situation that Justice Tarwater mentioned, you know, if the employer instead brought a contribution claim against the employee in the underlying tort action, would your position be that the preemption rule wouldn't prevent that?
Well, I don't think it
Because
would.
the same sort of evidence, of course, would come in that situation, right?
Yeah, it is. And I think it's one of those situations where you could have the preemption rule apply, and, go through litigating the case. I mean, the fact is that, that possibility does exist. However, it's unlikely to be deployed as a strategy. From a practical perspective, it's not a great idea to point the finger at your own employee. That's also a concern that we've expressed in our brief, which is that particularly in Jones versus Wyndham, the Court of Appeals, they expressed reservations based on the continued existence of contribution in limited circumstances.
So you're essentially arguing for the preemption rule already, with a couple of exceptions that I've heard: punitive damages claim, contribution claim. Are there any others?
Well, Your Honor, these are potential.
It's getting kind of full of holes.
Well, and Your Honors, I would contend, first of all, once again, we do not contend that the punitive damages exception should apply. We don't think there is a standalone claim for punitive damages. The Colorado Supreme Court expressed very good rationale for that in their decision that they issued in 2017.
But the statute that I referred to earlier specifically provides for punitive damages in a vicarious liability claim if there's clear and convincing evidence of reckless training, hiring, that sort of thing.
Yes. Your Honor, my response would be that, once again, the punitive damages exception is not before the court. The plaintiff has not asserted a claim for punitive damages. It's purely compensatory damages.
Okay.
Mr. Patrick, if
Yes.
we were to decline to adopt the preemption rule, are there some best practices that you think trial judges could adopt to limit any potential prejudice to defendants in these cases?
Well, Your Honor, there are procedural mechanisms that exist. We're not going to argue that they don't. There are obviously rules of evidence and rules of discovery. But at the same time, plaintiffs being permitted to pursue multiple potentially superfluous causes of action, we would contend that that prejudice starts at the outset of the case.
But doesn't that happen in every case, potentially?
I mean, it could.
Given that we have inconsistent theories of liability?
And if it's truly superfluous, couldn't you do discovery and then make the appropriate motion to dismiss?
Well, but it's a little different because the defendant actually has to accept vicarious liability. So that element of discovery has already been completed once they've admitted that in their pleadings.
But how is it truly superfluous if, I think I heard you acknowledge that the existence of this direct negligence claim can and often does actually impact the allocation of fault. So how can it truly be superfluous which I take to mean, really says nothing, does nothing,
Well, it's,
if it does actually affect the allocation.
well, so my answer to that would be that it's superfluous to the extent that the plaintiff already has their remedy. Because vicarious liability has been admitted, the employer is already going to be on the hook for the employee's conduct. I see my time is about to run out, so if there are any further questions.
Thank you for your
Thank you.
argument.
We have a chart. Let me give it a second to set.
Oh, I forgot about your chart. Got to get the chart.
Well, the last time Justice Tarwater argued, he had a chart too.
I'm sorry?
The last time Justice Tarwater argued, he had a chart too, so.
It just
Right.
makes it exciting.
I'm not sure that's very good precedent.
That in these appellate arguments, that does qualify as excitement. Chart.
The bar is low.
My chart, by the way, was bigger.
A lot bigger.
Thank you to Jacob Vanson and my firm for helping out with this.
I've been sitting there for 30 minutes more nervous about setting up this chart than not.
And let me apologize to all the people here who are going to now be blocked from seeing some things. Bring it closer.
We do want you to be close to the microphone, Mr. Caparella.
So I don't
as you
have
know,
to
'cause-
stray very far, yeah.
Right, because we are live streaming.
Right, if you bring it even closer.
Even closer.
And then towards me. Okay, that's good.
We also learned that during Justice Tarwater's argument.
And we also, I can't hear you, Your Honor.
Is my mic not on?
Think so.
Can you hear me now?
I can't.
Yeah.
Maybe I'm not getting close enough to it, okay.
All right, fire when ready.
My name is Donald Caparella, National Bar, representing Melissa Benz. Joining me on this case is Tyler Yarbrough, Jacob Vanson, and who are not here today, John Griffith and Jonathan Lawrence. In 1992, when Tennessee adopted Tennessee Law of Comparative Fault, they were dealing with two doctrines that created tremendous unfairness and had for decades in Tennessee. The first doctrine was the doctrine of contributory negligence, which if the plaintiff had just even a small amount of fault, barred them from any damages at all. So there was no linking of fault to liability with contributory negligence. The other doctrine that was addressed in the McIntyre case was the doctrine of joint and several liability, which affected defendants in a similarly unfair way. Because if you were a defendant, and there were multiple defendants involved, and you had just a little bit of fault, and the other defendants weren't necessarily responsible or couldn't pay, that defendant would have to pay, they'd be responsible for the amount of fault way in excess of what they actually did in that case. So again, there was no linking of fault to liability. And what the court in the Supreme Court did in adopting Tennessee Law of Comparative Fault was to link fault with liability because it best achieves the concepts of fairness and efficiency. And I brought the chart to explain, well, because it's easy when you're dealing with multiple individuals to actually have somebody to point to on a chart. I imagined a multiple standard case where you have a plaintiff who has filed a lawsuit against an employee and an employer, and they've alleged vicarious liability. And the employer, and has also alleged direct claims against the employer for negligent supervision, retention, hiring, all the typical direct claims. And then the employer has turned around and alleged comparative fault against the plaintiff. And then there's a second defendant in this case. And if it's a premises case, like this case, it could be a cleaning company that's a separate corporation. If it's a trucking case, it could be a second driver. But there are many cases where, as Justice Tarwater asked, you have multiple defendants. And Tennessee Law of Comparative Fault deals with multiple defendants. When you have this basic scenario, the employer under the, and this is what Tennessee law is right now. If Tennessee law, under Tennessee law, there's the Tennessee Practice Jury Instruction 3.55 that says that for purposes of the employee's fault, the employer and employee are one because of vicarious liability. So whatever fault the employee gets, the employer is financially responsible for. They're not at fault, they're just financially responsible for what the employee did. And also under Tennessee law, we have Tennessee Practice Jury Instruction 3.56, which says when there are direct claims of liability, the jury gets the full picture and can assign fault to the plaintiff, to the employee, and the employer for their direct negligence claims. And in Tennessee, those direct negligence claims are separate claims. And if they sue a second defendant because a second driver was involved in the collision or a cleaning company may have been responsible in the spill in Primus's case, they're on the jury verdict form, and the jury or trial judge allocates all the fault. That's Tennessee law. It's been that way for a long time. We have jury instructions on it. What the preemption doctrine does is it says if the employer admits vicarious liability for what the employee did, all their fault is just gone. It's off the table. And therefore, they're essentially assuming that under the preemption doctrine that the only cause of this injury is the negligence of the employee. Nothing we did could, in every case, cause the problem. And the preemption doctrine kicks in at the pleading stage. So there is no discovery as to what anything the employer did. They can have a terrible practice of hiring incompetent employees with lots of DUIs in their background. And maybe they hire an employee with a DUI in their background, and then that employee is driving drunk and causes the wreck. And they get to hide that misconduct. They could have, in the facts of this case, we could have a situation where the employee was not trained, maybe it's their first day, maybe it's their second day, to never abandon a spill that you cause. You must stay by there. And the facts in this case, since we're on judgment of the pleadings, it's undisputed that the employee abandoned the spill. Under that scenario, if the employer's fault in not training them to never abandon the spill, if their fault is off the table, the employer doesn't even exist to the jury or fact finder, then the plaintiff is fighting a comparative fault with an employee who's looking not really that negligent because they didn't know any better. They weren't trained in a particular way. So it affects the allocation of fault in a significant way, even in a simple case. But when you add a second defendant, it's even worse because the second defendant, they, for example, let's say, and this is the twist that I think really makes my point. Let's say the plaintiff just sues the employee, the employer vicarious liability, and the employer for direct claims. Then, and the employer then blames a second defendant under affirmative defense comparative fault. They say the second defendant is potentially at fault. The plaintiff can then bring them into the case, and then the employer can admit vicarious liability, step out of the way of any fault, and that leaves the second defendant potentially holding the bag. Because as Your Honor said, of course it skews the comparative fault allocation if one of the potential tortfeasors is not involved. Now, my opponents have argued in their brief and today that, well, what about all this unrelated conduct, all this inflammatory evidence that can come in that would cause the jury to be furious at the employer for all their misconduct? Well, you don't get on the jury verdict form in front of a jury with a trial judge unless you have a prima facie case that one of these direct claims proximately caused the plaintiff's fault. And the preemption rule is particularly pernicious because it stops everything at the pleading stage. So that's why, since 2018, 6 of the last 7 cases around the country, all involving comparative fault jurisdictions, have rejected the preemption rule, including Georgia and all the other cases listed.
So you're saying the federal district courts are just taking the wrong path now?
Well, they were doing a guess about what you would do. And in 2015, I'm not even sure how many of you were on the bench then, but they were making a guess. And 2 of you, 3, my mind doesn't work that way. So They were making a guess, and it was a flawed guess for reasons very clear. The Ryans case, which is the case that started it all, relied on Georgia law almost exclusively. It also relied on a Western District of Tennessee case that was only applying Georgia law, and that case would clearly come out differently today. So when Georgia says we now have comparative fault in Georgia, and Justice Bivens, you're right, Georgia law and Tennessee comparative fault law are identical. The grounding of all those federal cases is now greatly suspect. They also rely on the Clooney case from Florida, but that case has been raised in great question because of subsequent cases that said that case should be overturned because Florida now has a statute on comparative fault. So the underpinnings of all those federal cases, which began with Ryans and comes out, have been completely shaken and I would say even erased. A recent case, the Swift case, came out in 2022, and it cited Georgia law for adopting the preemption rule, even though Georgia law had changed, and it cited the Illinois state for the preemption rule, even though 2 months later, the Illinois court said the preemption rule no longer applies. Now, I would also submit that while we have a common law doctrine of comparative fault, to some extent, that common law doctrine of comparative fault has been adopted, has been codified by the Tennessee statutes. Justice Kirby, you mentioned the punitive damages statute. And I think you're exactly right. That statute would essentially be abrogated by the preemption rule and would also, it's a statement from the legislature that we want punitive damages to be handled in that way. But there's another statute that is coextensive with that statute. It's 2939-102J. That's within the non-economic cap statutes. And that statute says, the liability of a defendant for non-economic damages whose liability is alleged to be vicarious shall be determined separately from that of any alleged agent, employee, or representative. That's 2939-102J. So that statute contemplates that an employer's liability for non-economic damages may differ from the liability of its employee depending on the comparative fault of all the other potential tortfeasors.
Mr. Caparella, let me ask you if your position is that the preemption rule is never appropriate, should never be adopted by our court, or that it could be adopted in certain situations. For example, if there's not a punitive damages claim, or if it's a employee-employer case without co-defendants.
I think you're presented with a yes or no, preemption rule or not preemption rule, by the way this case is currently situated. This would be a terrible candidate to adopt a hybrid rule about preemption involving situations that don't exist. Like, we don't have a punitive damages claim. We don't have a second defendant claim. We don't have gross negligence. We don't have any of those things. So this would be a bad candidate to guess about a preemption rule. Even the McIntyre court in comparative fault didn't anticipate all the things that have come up since then because they said it'd be giving advisory opinion. So I think this would be a very bad candidate to try and guess on something, right? I think the only issue you're presenting right now is preemption rule or not preemption rule. And I think you should be guided by the fact that almost all the jurisdictions since 2018 that have have addressed the issue have rejected the preemption rule because of their comparative fault systems. Opposing counsel cited California and particularly North Carolina, and North Carolina is still a contributory negligence state. That's my home state where I grew up. They still have contributory negligence, so it's of no guidance to this court. Now, we also have another statute that I think that evinces the legislature's.
Mr. Caparella, could I interrupt you just for a moment? I do want to ask about, the defendant's argument, or the defendant points to the Ali versus Fisher case,
Yes.
which, and it cites that for the proposition that vicarious liability is an exception from comparative fault. What's your response to that? Why is that not significant in considering, whether our adoption of a comparative fault regime is a reason to reject the preemption rule?
The statement in Alley v. Fisher needs to not be reviewed in isolation. The Alley versus Fisher case involved a situation where there was an entrustor of a vehicle to an entrustee. And the jury found that the entrustor was 20% at fault and the employee or entrustee, it's a principal agent situation, was 80% at fault. And then at the trial court level, somebody said, well, we want to make the employer vicariously liable. Now, the employer didn't admit vicarious liability. It's just the trial judge found there was vicarious liability. So the issue that went to this court was, is negligent entrustment imputed liability, like vicarious liability, or is it fault-based? And this court said that we believe that the separate claim of negligent entrustment is fault-based, so you must compare the fault of the entrustor and the entrustee. And then they went on to say, in rare exceptions, do we not follow the absolutely important rule, which is you must consider the fault of all the tortfeasors. And then they listed vicarious liability as an exception, but I think it's actually kind of wrong to think of it that way, because vicarious liability is not fault-based. So it's not an exception to comparative fault rule, because vicarious liability is simply financial responsibility for the fault of another. A vicariously liable defendant is not on the jury verdict form separately, so their fault is compared. They just simply assume the fault of the employee. So I think that's not really, respectfully to that court, an exception to the rule that all tortfeasors must be considered. The only other exception that the court recognized outside of that was when you have an intentional tortfeasor and a negligent tortfeasor and their fault is being compared, and there's a public policy that says if your job is to act in a reasonable way to prevent an intentional tortfeasor from hurting you, you don't get off the hook for your negligence by blaming the intentional tortfeasor that you should have stopped to begin with. And that simply does not impact the preemption rule at all, has nothing to do with this case. And I would submit that the Alley versus Fisher case, because there was no admission of liability, no discussion of the preemption rule, really has nothing to say about this issue at all. So I've talked about how, there's a third statute, though, before that Your Honors mentioned the punitive damages statute. I've mentioned the similar statute about how comparative fault, the non-economic damages may differ from the liability of its employee. So it's 2939-102J. But the third statute is essentially the legislature has codified one of the basic principles of Tennessee law of comparative fault, which is that multiple defendants are held liable in a negligent action, and they shall be severally liable for the percentage of damages for which fault is attributed to such defendant by the trier of fact. So now by statute, we have several liability, and all those people's fault must be considered. And then they go on to say that that includes non-parties. It includes immune tortfeasors. Their fault must be on the jury verdict form. It includes settling tortfeasors who are out of the case, not parties, but their fault must be included. And so why would we say a jury, to get the full picture, must consider all this fault, including immune tortfeasors, who you can do lots of discovery on to find out what they did and how much fault they had, and settling tortfeasors, who you can do discovery on and find out how much fault they had so the jury can do a fair allocation. But just remove the employer and allow the employer dictate the lawsuit that they want to defend. They don't want to defend the lawsuit where they have horrible hiring practices or horrible supervision practices, or the example Justice Tartaroy you brought up of they don't want to defend their conduct. The employee is very often not sued in premises cases because you don't know who they are. You don't have an incident report very often. So they want to point the finger at the employee because they want their bad conduct out completely, which they could do, and I argue would probably do almost every time if they have really bad potential conduct, because they want to point the finger at the employee, and while they may be vicariously liable for that, their bad conduct is not considered. And that puts a situation where you don't have all the people at the table who actually potentially caused the injury. And that is the the canard, I think, that they're arguing is that you have all this unrelated conduct that the poor defendant's going to have to deal with. Well, there's at least a couple, I think, former trial judges on this bench. That's what trial judges have been doing for a couple hundred years. They have the rules of evidence. If it's unrelated conduct, it doesn't even come in, and the jury never hears about it. If it's potentially inflammatory to the point that it's unduly prejudicial, then the trial judge can weed that out as well. So we think that that is a perfectly appropriate fail-safe to prevent defendants from being put in, as opposed to just litigation, as you say, just litigation, you got bad facts to deal with. The problem with the preemption rule is it cuts off everything at the pleading stage. You don't ever get to those bad facts. You never get to know anything because they say it causes too much trouble, too much confusion, too much discovery. But the South Carolina Supreme Court said, when it rejected the preemption rule, the argument that the court must entirely preclude a cause of action to protect the jury from considering prejudicial evidence gives impermissibly short shrift to the trial court's ability to judge the admission of evidence and to protect the integrity of trial and the jury's ability to follow instructions. So the preemption rule says every time it's only the employee's fault, our fault doesn't matter. At the pleading stage, just shut it down. And I think that's why the strong trend since 2018 is towards rejecting the preemption rule. I also think that in addition to the statutes that have been adopted that shows what the legislature thinks is the appropriate rule, which would not be the preemption rule, we have the judicial economy argument about contribution. I think Justice Sirota, or one of them years ago, said that
One of those guys.
one of those guys. It's funny, I was involved in the McIntyre case, so you'd think I would know who they were, but anyway. The elimination of joint and several liability has been greatly overstated, or the death of it, quoting the Mark Twain comment. You know, the reports of my death have been greatly exaggerated. The reports of the death of joint and several liability have been greatly exaggerated. And of course, we still have joint and several liability in narrow circumstances, like products liability. But we clearly have joint and several liability in responding at superior situations, when there's an employee or an employee. And the way that would have to work under the Uniform Contribution Among Tortfeasors Acts, 2911, 102, and 103, is you would have this trial that I have on this chart, and then after the trial is concerned, let's use the preemption doctrine. Let's say the employer is gone. Okay, you'd have this trial. The plaintiff would get whatever fault they get. The employee would get whatever fault they get, and the second defendant would get whatever fault they get. And then the employer could sue their employee for contribution. So for the first time in a second trial, you would have the employee's fault and the employer's fault measured against each other. But without the preemption doctrine, you simply do it all at once, and the contribution action is effectively tried at the same time as the original action is. So you don't have judicial economy if every time you have the preemption rule in play, you're going to have a second contribution trial. Now, defendant says, well, we probably wouldn't do that very much. But there are lots of times where an employee might be somebody that would want to sue, and of course, you're making a rule for every case that this would come up in. So I would submit that that's another reason why the preemption doctrine should be rejected. So I'll close by getting back to Justice Page's comment about federal courts. I mean, how many years of federal courts does it have to be before we say, okay, they got it right, let's just do what they did? You have to look at, first of all, none of those cases went up to the Sixth Circuit. So you have no guiding principles from them. Secondly, if you read them, they are all drawing from the Ryans case. They're flawed, and you have no obligation at all to accept their guess about what a court in 2023 was going to do.
Well, even if it had gone to the Sixth Circuit, I recall writing an opinion in which I said that I found a Sixth Circuit opinion neither controlling nor persuasive.
I believe I remember that too.
And I remember reading it too, and that's exactly right. Yeah, it's your call. You're the one that understands Tennessee constitutional law, or in this case, Tennessee statutory law, and so it's your decision.
Mr. Caparella, let me ask you about this. I think one argument in favor of adoption of the preemption rule, even in a comparative fault regime, is that direct negligence claims really should be or are, derivative of the negligence claim against the employee. I take it you would disagree with that, and I just would like to hear your thoughts on that and your response to that. I mean, under your chart, I suppose the argument that I just outlined would suggest that, the two top boxes should simply be combined, if that truly is the proper allocation of fault.
Well, let's just deal with negligent training as one example of all the derivative claims. If you have a prima facie cause of action against the employer for negligently training, let's say they never trained the person to never leave a spill unguarded, even if they think they can leave for 30 seconds to get a mop. 30 seconds is okay. If you have that, and that is not considered, well, if you have that claim, then the fact that the employee followed that rule, or wasn't properly trained, the claim for negligent training against the employer is a separate claim with a separate duty to the public. The employer has a separate duty to provide a safe place by having properly trained employees. So the actions of the employee is simply a matter of causation for whether the employer's negligent training caused the claim. So it's not derivative in the sense that they, like a consortium claim where there's no additional conduct that you have to consider. Here you have separate conduct for the employer who negligently trained their employee, and if the employee acted negligently, then they work together. Essentially, the preemption rule argues that the only cause of a slip and fall like this is what the employee did. There's nothing, our training just doesn't matter because we choose not to defend that claim.
Well, wouldn't they say, I guess with respect to causation, that any negligence of the employer in training or supervision or hiring is simply a cause of the employee's negligence?
No, it's the reverse. It is a cause. The problem is that the cause or a cause. And for all these years in Tennessee, we've had separate direct claims. And employers have a separate duty to the public that is different from the duty of their individual employee who may or may not be negligently trained or may not be negligently supervised. If the preemption rule is adopted, then they lose all incentive to do any of that very well, because then the jury never hears about what they did wrong. And as Justice Tarwater said, there are many situations, if we don't know the full story, where the employee might be very sympathetic because of the predicament they were put in. It's their first day. It was their second day. Or they weren't, in other words, we can't compare the fault of the plaintiff and the employee unless we know what the duty of the employee was, and the duty of the employee is informed by the context in which they were supervised, trained, retained, hired, etc. So the word derivative doesn't really mean anything except for to say that they are connected and overlapping. But the fact that you have negligent training claims, it is a separate claim that has a connection. It's overlapping, and to cut it off at the knees in every case at the pleading stage is why the preemption rule is a bad rule and is also inconsistent with Tennessee's law, which says that in every situation, the fact finder must be able to consider all the potential tortfeasors, including immune tortfeasors, arguably derivative tortfeasors. Remember, it's derivative, not like a consortium claim. It is actual separate conduct that must be considered, and the jury must get the full story.
But you would agree that you can't have the direct negligence claim against the employer without a viable negligence claim against the employee.
Well, in almost all circumstances that's true, but I advise you to look at the Illinois case, the Illinois Supreme Court case, because in that situation, the driver of a truck was sent to get a really heavy 3-ton piece of equipment. And they put the equipment on there, and the driver said, "I don't think you loaded it right," and said to the people that loaded it, "You didn't load it right. I have a problem with this." And they said, "We think we loaded it right." So he called his supervisor and said, "Well, what should I do? I have a problem here." And the supervisor says, "Well, we really want this load. I order you to do it, but be safe." course, what happened is the thing fell off and horribly hurt somebody. The jury in that case found that under that circumstance, the employee was pretty darn innocent to the point that they actually awarded them zero fault. And the trucking company, through their negligent supervision claim, was found 100% at fault. Now, that's an unusual circumstance where you have an employee who's stuck between a rock and a hard place. Do I do what my supervisor says and follow this and trust that he knows more about what I'm doing than I'm doing because he's been there years and I just started last week, or get fired? And that's an incongruous situation to put an employee in. And so there are not many examples, but that's one from 2022 where they rejected the preemption rule. There are circumstances, I think, that could happen where an employee is very innocent, maybe gets 5% of the fault, and the employer, who really should get a lot more fault, is off the table. So therefore, if the plaintiff has some contributory negligence, comparative negligence, their fault is going to be escalated. And I put 40% on here, not because that's what happens in every case, but because that shows you how close it can get before the plaintiff gets nothing. If they get another 10% in the scenario I just gave you, because the employee is very sympathetic, they might get nothing. Now, my opponents say it doesn't affect the damages at all, but it does affect the damages in this way. Every percentage of fault that the plaintiff gets, below 50%, reduces the amount of their compensation and affects their damages. Every percentage of fault that this defendant gets, the second defendant gets, I guess you can't really see that, can you? The second defendant gets, would cause them to be more at fault. So you aren't linking liability to fault, which is what McIntyre says you must do. And the preemption rule is all about not linking liability to fault because they want to defend the lawsuit they want to defend, which cuts out all this other stuff. So we would ask that this court reject the preemption rule. I don't have much time left, but I'll stand on my brief on the premises argument they have. I think they have waived it in the sense that this court can and should only get to issues that were properly certified. This is a Rule 9 appeal. There is no Court of Appeals opinion, and I believe that you don't need to adopt a questionable rule from Texas when our premises law works just fine in Tennessee. So you should not even address that issue for the reasons I said in my brief. So we ask that you affirm the trial judge's decision to reject the preemption rule and reject it for Tennessee for all cases.
Thank you.
Thank you. We'll have you move this.
No, probably knock it over. Lot to unpack there in a very short period of time. The first thing I'll start out with, since he kind of teed me up for this, was Mr. Caparella's last argument about some sort of waiver and non-certification in the trial court. Our motion for judgment on the pleadings in the trial court raised the additional issue involving Texas law. Texas has decided to impose a rule in premises liability cases that additional claims for negligence, such as negligent hiring, training, everything else, should not be asserted because it is logically inconsistent with premises liability law. We asserted that in our motion in the trial court. It was raised in our Rule 9 motion in the trial court. The plaintiff didn't even address waiver in the trial court. And it was in the trial court's order certifying this for a Rule 9 appeal, which of course we appealed from the Court of Appeals' denial of that. But the trial court specifically included language regarding that it was an issue of first impression under Tennessee law. So with all that in mind, we respectfully contend that there was no waiver.
Counsel, let me ask you a question that I wanted to ask you first time around. I actually wanted to ask Mr. Caparella this too. But this case of Ali versus Fisher, what is your position on that case? Is it controlling? Is it persuasive? Is the statement dicta? Should it inform our decision in any way?
It is my position that it should inform your decision today. It is true that Ollie versus Fisher, there was no vicarious liability claim that was asserted in that. It was just negligent entrustment. However, they did go into detailed explanation of there being exceptions to Tennessee's system of comparative fault. And that kind of links to another point that I was...
But to that point, it doesn't, and Justice Tarwater specifically mentioned dicta. Isn't that just the definition of dicta?
I think it was part of the court's rationale for its ruling, and part of the court's ruling. So we contend that it's not dicta, and that it speaks to the fact that there are exceptions under Tennessee law. And in Ollie v. Fisher, they're specifically referencing other cases for that proposition.
It grew some legs in the federal courts.
It certainly did. And that leads into another point, which was there was a lot of argument about the Ryans case. Ryans did not just rely on Georgia law in its rationale. It also relied specifically on Ollie v. Fisher, which we contend should guide this court's analysis. But in addition, looking at the subsequent federal authority, which Your Honors may well or may not take as persuasive, but we contend that you should follow the federal courts. They reanalyze the preemption. They reanalyze all the other jurisdictions who have addressed the preemption rule, the non-preemption rule. Some of the cases in the Middle District, even in the I believe in the trial court, the plaintiff's attorneys relied upon Jones versus Wyndham. So the federal courts even looked at that. So with respect to Mr. Caparella's argument, we would argue that the federal authority is more persuasive than he was arguing. Now, finally, actually, and this is on Ryans too, with relation to the Georgia law, Georgia's decision to abrogate a common law rule, in this case the preemption rule, through the legislature, that's the legislature making a decision, and the legislature can do whatever they want. So it's distinguishable from our system of common law. Another thing is there is a case from Wyoming issued in 2018, and of course I would forget to bring it over with me. I believe it was called, I've got the title here, Bogdansky versus Budzik. Wyoming actually has a comparative fault system that is spot on to ours. And in that decision, the Wyoming Supreme Court determined that the preemption rule was entirely consistent with Wyoming's system of modified comparative fault, which is, once again, the claims are barred if the plaintiff is 50% more at fault. With that, Your Honors, just to summarize, we contend that the trial court should be reversed.
Thank you, counsel, for your fine arguments. The court will take a short break, 5 minutes or so, and then we'll be available for 15 minutes for the TBA boot camp participants. Mr. Ibram?
All rise.